So we'll have actually two issues today. Document production and enforcement of arbitral awards. And we will start with document production. And Laura Azaria is a counsel at Tlv Geneva, and she is an international arbitrator, graduated from the University of Geneva, and studied for LLM at Columbia Law School, and recently elected as Arbitration Future Leader. Now, the Swiss Arbitration Association has recently published a white paper on document production, which is one of the most sensitive and complex stages in international arbitration. The paper highlights the delicate balance between transparency and efficiency, stressing the need to reveal relevant information without allowing the process to become abusive or excessive. And Laura, I would like you to share with the audience what challenges and problems you recently your research identify regarding document production in arbitration.
Document production. So the other white paper on document production is particularly interesting because it was prepared not only by lawyers, and trust me, I have nothing against lawyers, but it was prepared by our clients. It was prepared by an experienced group of in-house counsel from diverse jurisdictions and industries who are frequent arbitration users. So this white paper brings a very practical and business-oriented lens to the issue of document production. And the findings of this working group can be summed up in one word: frustration. Many, and that's unfortunate, many users see document production are very frustrated with document production for two main reasons. First, because a separate phase on document production has become standard practice in international arbitration, and this is even the case in disputes between parties from civil law countries. We see that tribunals and parties tend to agree on document production, on a separate phase on document production, without first carefully considering whether this is appropriate in the specific case. And this obviously leads to an increase in duration and cost of the proceedings. So to conclude on this first question, the working group's view is that the current practice in document production is a burdensome, costly, and often very ineffective process, and that this undermines the attractiveness of arbitration. And these findings are very concerning for our practice, and we must address them.
True. So what are the conclusions or recommendations that emerge from your study?
The other white paper on document production doesn't propose abolishing document production. Instead, it calls for a readjustment, a return to a more restrictive approach to document production, as actually it was envisaged by the IBA rules on evidence, originally envisaged by these rules. Maybe a word on AI first, before turning to the recommendations of the working group. AI will be useful to make the process more efficient, but because parties will use AI, already use AI to craft narrow document requests, and tribunals can use AI to review the requests. But AI will not solve the underlying problems. AI will not solve the core issues, because the core issue, as we just discussed, is conceptual. So we need to rethink how and when document productions are used. And that's exactly what the IICA white paper on document production suggests. So let's turn to their recommendations. There are quite a few recommendations, and I will not have the time, of course, to address all of them. But so there are recommendations. There are concrete proposals actually by the working group, and the IICA white paper includes a toolbox on how to make document production more efficient, both before the arbitration and during the arbitration. So before the arbitration, one of the recommendations is for the parties to draft arbitration clause and to include document production in these arbitration clause. Parties can first exclude document production in these arbitration clause. That may sound extreme, but we see some key users that have taken this approach. And parties can also limit the scope of document production. They can do that by capping the number of requests. They can do that by limiting limiting requests to specific documents and not categories of documents. And I found it quite interesting. They can also do that by binding the future tribunal to a restrictive interpretation of the materiality standard. And then, if I have some time, yes, left, and then during the arbitration proceedings, it is for the tribunal to make it more efficient. So tribunals can also limit the scope of document production. And one of the suggestions of the working group was for tribunals to impose on the parties to integrate document production requests into their written submissions, and then to forego a separate document production phase.
Thank you, Laura. And I'll move to you, Edna. Edna Sussman serves as a full-time arbitrator with over 300 arbitrations and 200 mediations. Edna has published and lectured extensively and wins annual recognitions and awards as a top arbitrator. Edna is a well-experienced American arbitrator and attorney. Could you explain how the discovery proceedings are perceived and practiced in the US, especially in arbitration? And the difference between EU, America, you have here the microphone.
Yes? It's on. So I just want to start by saying that I think people tend to conflate, not to distinguish as much as they should, between court discovery or disclosure and arbitration, and then they further fail to distinguish or conflate domestic versus international arbitration. So courts, as you know, are quite generous as compared to arbitration, although even the courts in the United States have changed the federal rules and have gone from what can lead to admissible evidence to now having to be relevant, and an interesting concept, which I think we can also think about in arbitration, the idea of proportionality. On a $1 billion case, you might think it appropriate to permit a little more disclosure than a case that's $10 million, for example. So I think that's an interesting concept that we can carry over. Then the difference between arbitration that is international and domestic. Domestic cases are conducted very differently. We don't have multiple successive rounds of submissions. There is discovery first, generally speaking, and then there is one round of submissions 2 weeks before the hearing. I got to tell you, I do about half international, half domestic. I think that both are very fair processes. There is much less time devoted, I think, to writing these extensive memorials. We do have some depositions, and that kind of brings me, generally speaking, which brings me to one of the points that is raised in the paper. If you read the actual paper, you know, if you have two civil law counsel with civil law parties, do you bring up the subject of documents at the first hearing or not? And we encountered something very similar to that in domestic arbitration in the US, because in the old days there were no depositions at all in arbitration, and then people started to talk about it, and we used to think, should we bring it up? Then they're going to think they can do it, and so maybe we shouldn't bring it up at all. And my recommendation is, even if it's all civil law in terms of the parties and counsel, you should bring it up at the first conference, and you should use the first conference, which is happily a very good recommendation about really using more contact with the parties to manage the process, because then you can bring it up. Otherwise, you have no control if you don't bring it up.
Yes, having heard Laura's recommendation and conclusions, so what is your comment and reaction from your own perspective?
Yeah, I'll say there are two sets of comments really in the IICA publication. So one has to do with drafting stricter language than the IBA rules. And I think it was interesting suggestion to bring that up at the first conference of the parties about whether they want to change it to a more restrictive standard. So I think that's interesting. Having the corporate lawyers put it in their contract, I don't know, I always wonder, do you want to trust the corporate lawyers? Do you want to trust the arbitrator working with the parties at the time that they actually know what the dispute is? So that I'd be a little more careful about. But I do like that there is a lot in the recommendations about meeting with the parties and talking to the parties. And I would expand it beyond what is in the recommendations about talking about the document inquiry at the first conference, but actually using the first conference. 15 years ago, I gather, in ICC arbitration, they really didn't have it very much. There was no first conference. But you can use it beyond documents. Should you have some, what I call dispositive motions, to have summary adjudication of some of the issues, that could get rid of a whole lot of document disclosure. Is bifurcation in a particular case appropriate? That might limit discovery in the first phase. You may never get to the second phase. So not just jurisdiction is a bifurcation question, but many other things. So, and getting to know the case right away. And do you always have to have that, these successive memorials and then the disclosure and then the memorials? Really think the process, and maybe you don't need to do so many. Should there be an initial disclosure of some even if you're doing the traditional, multiple submissions, you want to have some very limited disclosure of something very specific. I mean, I find it a lot in damages. They have absolutely no idea what the numbers are, and so the first submission doesn't really have anything useful on the damages. So if you have, really specified by the tribunal, not real disclosure, okay, save that for later, but just very specific information about the numbers, you can actually get something meaningful on the first round on the damages, so it's not all in the second round. So, comparable licenses are important. Should you have a limited exchange right up front, really directed completely by the arbitrator, so there are no disputes at that point. So I just thinking creatively and figuring out how to manage the process better is bottom line good, and it's in the recommendations, which I was happy to see.
Mm-hmm. Thank you very much, Edna. And Dr. Reli Leshem. Reli is a senior partner at Meitar and the head of the Israel's largest litigation department. I first met Reli when he returned from his PhD studies at Harvard, and he was a law professor for civil procedures course in Tel Aviv University, and I had the privilege to be his students in this course. And the material is terrible, so boring, civil procedures. But it was so interesting and even fascinating. So I don't know if it's a coincidence that I become later a law professor at civil procedures. But really, could you share with us from your academic perspective how these differences and sometimes conflicting philosophies towards discovery proceedings have evolved?
I think that the issue of document discovery really has a philosophical aspect to it, which I think is one of the core issues on the lawyering and on procedure in general. Because let's say that I can produce a process that will take 3 years, will cost $2 million, and will yield a result that is 90% close to the true facts. I can do the same arbitration in 1 year for $500,000 but it will produce an 80% resemblance to the true facts. Which is better? This is a very difficult question, assuming that we do believe that extensive discovery eventually, putting aside the costs and the time, will yield a result that is closer to the truth. So this is a real difficult question, and I think it becomes more difficult in the international context because then it's a cultural issue. There are lawyers coming from jurisdictions where the finding the truth is at a higher level than the cost and economics of the litigation. There are other cultures where the issue of finding the most efficient and economic way to resolve disputes is the most important issue. So these are the two first problems. Then there's the third problem, which is right, because in arbitration we expect a more relaxed, flexible, and cheaper process. So how do we take the first two big problems and now adjust them in the realm of arbitration? So we do have a problem, and we can, when we see all the studies, all the recommendations, we do find that in the final analysis, the rules have to stay flexible to a large extent. And we also find that in, for example, arbitration clauses in agreements, before there is a dispute, there is almost never any reference to the issue of discovery, although discovery may be accounts for 40 or 50% of the cost of the entire arbitration. There is not a word. People tend to, for example, to discuss other procedural issues that will be in the arbitration, but there is nothing about discovery. This is because it is very difficult for parties to envisage what kind of discovery they might want to have before they know what disputes might develop, what would be the value of these disputes, etc. So I think that eventually we are left with very few tools to manage discovery in a case other than the discretion and wisdom of the arbitrators. Because we talk about that it has to be relevant, of course, we all agree on that. Materiality, of course, we don't want to work on discovery of something that may be relevant but is not material. And there is the issue that it cannot be burdensome. We also agree on that. But after having used these three principles, we are still at a very, I would say, a very low starting point to determine what discovery should be required in a case. So I think that the recommendation to have at a very early stage of the proceedings a hearing or a meeting with the parties if they can agree among themselves, or with the arbitrator if they cannot, to determine the level of discovery that is required in the case. And my proposal is to adopt 4 levels of discovery. The lowest level is no discovery at all, with very, very few exceptions. The second is very limited discovery, but some discovery. The third level would be broader discovery, but still limited. And the highest level will be full discovery, American style. Now, if these 4 levels are established, then the arbitrator at the very stage early of the arbitration may determine that the proper level for this arbitration is level 2 or whatever. Of course, he may change his ruling later on if he finds out things that were not apparent originally, but then the parties would know that at the level of discovery that they should expect and the level of discovery that the arbitrator will allow. Now we can even develop it further, and maybe if this falls into distinct levels, you can maybe even in an arbitration, in a arbitration clause in an agreement, the parties may agree that the level of discovery in this arbitration should be level 2, level 1, or whatever. I think this will sort of reduce the very broad discretion that now exists on issues of discovery.
Thank you, really. So you saved me the $1 million questions of...
I just want to add one
yeah.
thing, which is that CPR has actually done that and has guidance
Levels,
really
yeah.
for different levels you can choose.
No, so you saved me the $1 million questions about the golden path or the optimal approach for document production in arbitration. So I'll ask you another question. We had an inspiring lecture yesterday held by Bridget Marie McCormack, the president and CEO of the AAA, the American Arbitration Association, about AI, an AI arbitrator. So how do you see the impact of the fast development and utilization of AI on the approach to document production in international arbitration? For you.
Well, AI is something that is really very difficult, I think, to view and to understand where it is going, but clearly it will change everything. I want to look at it from the perspective of the cost of the litigation and the arbitration. And I think that the study that you mentioned was involved in-house lawyers. Now, I think that there is a difference between the approach or viewpoint of in-house lawyers and outside counsel representing an arbitration. Because in-house lawyers meet the issue of discovery in 2 points. One, they need to arrange the discovery in their company, which will take a lot of time and cost them a lot of money. And the second thing is that they will have to pay their lawyers' bills for extensive discovery. So I would say that in general, in-house counsel are less keen about discovery and therefore see less advantages of it, as opposed to lawyers that litigate international arbitration that see more, I think, more value in discovery and give more weight to its importance. Now, on the issue, AI, I think, will make discovery cheaper because you don't really have to go through your files, look for every document. You can really now, using search engines and search and keywords, etc., you can really do a lot of discovery very quickly, unless, of course, you need to redact significantly, because sometimes there are trade issues and trade secrets, so you need really to take the document and start redacting them. But putting that aside, the other advantage of AI, of course, is the management of the documents you receive. It is much, much cheaper and easier when you have AI that can do the work for you. And let me give you a little example. We had an arbitration in which the main focus of the arbitration was on a specific meeting, and the question was what said and agreed in that meeting. We had extensive discovery, but the discovery really didn't really reveal much about that meeting. And one of the witnesses for the other party, a key witness, said he attended the meeting and gave a very vivid description of what went on. However, since we had a very extensive discovery and since we had AI tools, we found an email by that person showing that on the date he said he attended that meeting, he was in Japan. So that mail was discovered, had nothing to do with the meeting, but it was part of the extensive discovery. Now, without AI tools, probably we would not be able to really find this mail and really and destroy his testimony. So AI tools, I think, will make discovery cheaper, will make it a better tool, and therefore I think that the result should be that discovery should be more extensive when we have the AI tools to get the documents and to process them.
Yes, thank you. AI is a really fascinating issue, and it's going to change dramatically the arbitration world and the world in general. But we are ahead of our last topic for today, the enforcement of arbitral awards. Even though arbitration is often praised in its finality and its global enforceability under the New York Convention, the reality is much more complex. In practice, enforcement had become the true test of arbitration. The stage where law meets politics, economy, and technology. In recent years, many parties have discovered the hard truth, that winning the case is only half the battle. The real challenge begins with enforcement. So this is why an effective enforcement strategy must be built from the very outset of every arbitration, not after the award is rendered. Today, our panel will explore this critical phase of the arbitral process, the obstacles, the innovations, and the evolving global trends that determine whether justice on paper becomes justice in practice. So I will start with you, Bernardo Cremades. Bernardo is one of the most experienced and well-known arbitrators in the world with more than 400 arbitrations. He is considered the #1 arbitrator in Spain. He is a law professor, the author of numerous books and dozens of articles. Bernardo serves as an arbitrator under the major international arbitration institution in the world, including the IICA. And Bernardo, I would like to ask you, could you highlight the main difficulties and challenges that the business and legal communities are facing today in enforcement arbitral awards?
Thank you, Menashe, for inviting me to be at this panel. When I appear in a panel like this, the question is very clear. How do you explain that Spain is becoming one of the most important clients of ICSID and PCA, newly with those renewal sentences, we are not facing the solution of that. And you will be very disappointed because I refused from the very beginning to accept to be in those panels or in our law firm to represent clients against the Kingdom of Spain, because I was appointed by the Kingdom of Spain for more than 30 years in the panel of ICSID, and I thought it was a conflict of interest, and that was the reason why I didn't accept. But anyhow, I was asked at the beginning by the Minister of Spain, what is your opinion about these disputes we have in front of us? My answer was very clear. Please settle the case before you go into trouble with so many people. Why? And they tried to explain me the reasons, and probably the reasons were four. First reason, immunity of jurisdiction. My answer was very clear. Spain has signed the Washington Convention. I mean, immunity of jurisdiction is clear. You cannot really defend yourself on that basis. Second question, most of the cases, most of the arbitration awards against the Kingdom of Spain has been sold to different funds. And then the answer to that is, well, the Kingdom of Spain signing the treaty, the international investment treaties, bilateral or multinational like the Energy Charter, it's intuitu personae. I mean, the Kingdom of Spain accepted to be, to renounce to the immunity of jurisdiction vis-à-vis concrete investor. and then it results that it appears against me enforcing the award, not the one with whom I admitted in the treaty to be submitted to arbitration, but a fund. Really, I think that's something to take into consideration. Third argument is the European law. They say the European law, and we remember Achmea, the European law says that the convention, that the agreement between the Spanish kingdom and the investors was at the end resulting in a payment which is considered illicit by the European Union. And that's the reason why probably the agreement is null and void from the very beginning. But my answer to that is, if I am an investor, do I care about the lack of consent by the European Union to the Kingdom of Spain to go into that? I mean, I am, and that's the reason why I go outside of the European Union to enforce that. And that's the reason why I have to admit that the US courts or the British courts or the Australian courts are enforcing those awards because they are not covered by the European Union legislation. So at the end, it's a question of looking after a place to enforce the awards which is not under European umbrella. And it's very curious that the vice president, the lady vice president, who was so important in order to fight this case, is now the vice president of the European Union responsible for that. And I remember a meeting at the very beginning with her staff. They told me, well, you are someone who is a very well-known practitioner in arbitration. You should defend the interest of Spain. And say, no, I am not, because I'm convinced you are not right. Say, you should be patriot, because a patriot should really defend the questions of the position of Spain. And that's the reason why I am a patriot, but I saw that after 10 years, the one who was patriot was me, recommending the settlement. And there is another fourth argument, which is more important, is immunity of execution. Immunity of execution against assets. Probably that's an important part, because we see that there are different proceedings executing those awards. For instance, last week in Holland, they embargo the dividend from the Kingdom of Spain due to the dividends from the air company, well, the air production of airplanes. I mean, that's really not juri imperii argument, because, I mean, dividends are not. But anyhow, other questions may rise. For instance, England. In England, they embargo the Cervantes building. Cervantes is an organization for cultural of Spain. Is that part of policy? Is that jure imperii? Very probably yes. So at the end, I think if I happen to be advising the investors, probably I should recommend to be very careful against what kind of assets they are trying to proceed. Thank you.
And thank you. And could you share with us an example or a case that maybe illustrates that challenges?
Challenges?
Yeah.
Against what?
Like, for example, the ICSID against Spain government. What?
Well, Spain has tried to go to the annulment of different awards, and sometimes they have accepted the annulment, and sometimes they have not accepted the annulment. But my impression is that the annulments, and you have the experience here in the local courts, I mean, are dealing with reasons that are not really the matter of the case. Because, for instance, I understand that your district court in Tel Aviv refuses to enforce an arbitration award just because there were no assets from
Israel.
Spain
Yeah.
in Israel.
Mm-hmm.
I mean, but that's not
It's true.
important.
You're right.
Because we are talking about recognition
Exactly.
and enforcement. And recognition
Has nothing to do with the assets in Israel.
Yes.
You agree?
recognition from the Washington Convention,
Mm-hmm.
it's like, it's not necessary because from the Washington Convention is very clear. So at the end, you will have to reconsider probably in your Supreme Court this decision because
As far as I know, there's going to be the Supreme Court this
very
case.
probably
Yes.
it's going to win in the Supreme Court and
Yes.
fix the jurisprudence for that.
Yes. Thank you. Thank you, Bernardo. And last and not least, the last speaker, Dmitry Dyakin. Dmitry is the head of dispute resolution at DGP Russia. He has academic degrees from Russian State University, Higher School of Economics, NYU, London Business School, Columbia Business School, and Dmitry is considered as a top arbitration lawyer in Russia. Dmitry, drawing on your extensive experience in arbitration in general and enforcement proceeding in particular, could you describe the particular obstacles you have encountered, including in the context of international sanctions?
Thank you, Menashe. I'm sorry for two things being...
Water. You need water?
Water doesn't help much. Sorry for being last, and thank you, Bernardo. For the fact I lost my voice a bit. Sorry for that. It's
Last night you were still in Moscow.
yeah, and I arrived late. So the topic is indeed quite interesting. However, you know, the problem is and problems are obvious. What was once very predictable and clear now is complicated by regulations, sanctions, creative interpretation by courts and institutions. So it's indeed a lot of challenges in this field. So I touch several obstacles. First, the physical obstacle. And I begin with the fact that, you know, the assets are frozen and accounts are blocked. So this is a very practical and difficult situation. So in this regard, we see kind of a paradox. On the one hand, awards in favor of sanctioned companies from Russia are very difficult to enforce within EU territory because they should be enforced in the blocked account. And, you know, it's it doesn't, in my opinion, it doesn't amount to the full enforceability and full recovery. On the other hand, the same problems the international companies face in the Russian context of enforcement. Very often, even if they win the award and obtain the award, it is difficult to get the funds from Russia, basically for the same reasons. If it's sanctioned companies, or you know the banks in Europe or UK would check the payment routes and also apply compliance, over compliance. And then, you know, the paradox situation is that it works both way. Effectively, both parties from different Russian and European companies face the physical difficulty of being enforced and transferred money. President of European Council, I guess. The second thing, we face now the growing uncertainty around enforcement around the recognition of awards under New York Convention. So very often courts in Europe and UK start to read sanctions into the notion of public policy under Article 5 of New York Convention. So on the other hand, Russian courts also have increasingly relied on notion of public policy, and being creative created the whole massive and body of justifications why the awards should not be enforced in Russia. For example, if the tribunal consists of members of from unfriendly jurisdictions, so that award would be under excessive scrutiny and might be not enforced in Russia. So these both examples creates a lot of uncertainty that goes beyond the merits of any particular case. As a result, creditors now fear that their, allegedly easy cases might not be enforced and recovered at all. So the third obstacle, just practical, from the practical point of view, is that institutions very often when they see the Russian parties, so they quite slow, so they try to apply administrative proceedings which become over-compliance again. They sometimes seek the licenses from OFAC or general license in the UK, for example, or any other licenses. Recently, in my SEC case, SEC asked us to obtain the license from Swedish Treasury to proceed with payment. It also concerns, the whole proceeding itself. It's becoming quite slow. It delays. Sometimes institutions delay issuing the awards and releasing the awards after settling the last payment, and that become quite disturbing. Also, very often Russian parties cannot proceed the payments in euros or dollars, and there is no alternative for that. Even in the local currencies, sometimes it's quite difficult. And also it concerns some other services, local services, for example, transcribers, paying the premises, cost of premises. One illustrative example I remember where some lawyers physically would have buried the cash banknotes, $20,000 to the building where the premises, and the staff undertook to count them. It took almost 2 hours to count all those banknotes and accept it. So again, probably the biggest thing which we could discuss is when Russian companies, sanctioned companies, would win the award, and then they try to enforce it, and try to enforce their opponents. Very often, in my cases, try to say, listen, okay, liability might be established, however, the enforcement should be into blocked account, which not in the interest of the Russian parties, and that's the whole new body of issue in arbitration. So we inevitably say, to be enforceable for this award, we need to change there are two options, basically. Either the tribunal should open this issue and not decide on which account should be paid first, and or it should decide this issue and determine what way would be effective in order to pay those awards. And we need to remember that one of the features of the international arbitral awards is it should be clearly enforceable.
Thank you very much, Dmitry. And wow, really exactly on time, like we like. And as we reach the close of this remarkable day, I would like to thank our distinguished speakers for the generosity of their knowledge, and to thank all of you for being here, not just as listeners, but as part of the growing global family of international arbitration professionals. Enjoy your day, enjoy Tel Aviv, and see you next year at the IICA International Arbitration Conference 2026. Thank you very much.